The Governance Committee to order. We'll start with a roll call. Counselor Lombardi.
Here.
Counselor Tabor.
Here.
And I am Counselor Cook, and I am here. The first item on the agenda is to review and approve the minutes from April 10th, 2023. Did everyone have an opportunity to review the minutes?
Yes.
Okay. Can I get a motion to approve?
So moved. Second.
Are there any questions or concerns? All in favor?
Aye. Aye.
Aye. The minutes from April 10th are approved. We start the bulk of our discussion today under old business on conflict of interest, which we started discussing at our last meeting. For those at home who were not have not watched the last meeting, we had a guest at our last meeting to go through the initial concerns around conflict of interest, and today we're going to go back through starting with the conflict of interest section within the ethics ordinance currently. And that's where we've begun the discussion.
1.801?
Yes, 1.801. So I'm going to go to conflict of interest here so everyone can see what I'm talking about. This is within the Code of Ethics. It's section 1.802.
So I mistakenly brought the wrong file. I'm going to go get that file.
Okay, okay. So let's go through first any reflections from the committee on our discussion last week, and anything that we want to make sure that we're addressing here when we're discussing conflict of interest in this section in particular. Does anyone have anything that they were particularly struck by last week we want to make sure we address?
We talked about a preamble. You know, what's the purpose of the conflict of interest law? And we've got a couple different tests in different places. Like in the city charter, conflict is defined as direct pecuniary interest, which is greater than any other citizen or taxpayer. But that's not in the 1.802. But that's in our charter. So those were some of our discussion last time.
Okay.
And I thought we had a good discussion about travel and entertainment and disclosure of that. And would that come under the gifts of more than 100?
Mm-hmm. Okay.
Yeah, I don't know that we had any more discussion of that than that of gifts and disclosure.
Right.
I know that I had some particular concerns too around it, making sure that we address that appropriately, because there are different categories around gifts and favors. There's a difference between, and there's also a difference between employee and an elected official as
Right.
well.
Right.
And in this, that we need to make sure that we're really clear, and I think that we all had expressed some concerns about Section A being very, very unclear, the very first part of this. You know, making sure that that's really specific and that everybody understands. Because the concept there isn't clear when the charter does suggest, we're talking about financial interests.
Right. Right.
You know, when you're looking at language that says anyone has any other private interest, well, you know, is your ownership in your home a private interest in the city?
Yeah.
Is your, you know,
Yeah.
that's just really not clear in this language. And so we need to be really clear with the language in ways that it's not clear, I think, at the moment. And so we need to clarify that. And then there's some things that are probably missing too from the conflict of interest section that we need to make sure are included. In that, I met with our former city attorney, Bob Sullivan, to sit down and discuss things that we could do to improve this section and things that may help clarify different sections. Do you mind if we turn to you, Mr. Sullivan?
Yes.
Can we turn to you for any insights you have into the conflict of interest section?
Absolutely. So what I had thought was going to be a kind of a logical approach to reviewing all this is to frankly just walk right through all the conflict of interest provisions and just, you know, read them, think about them, talk about them, and if you want to propose any amendments, you can propose them at that time. I will say this. There's basically been no amendments to this ordinance for more than 40 years. Some of it is outdated. Some of it is ambiguous and could be cleaned up. Councilor Cook and I have discussed this, and I have 2 pages of notes from talking with her about it. So, you know, she's ready to discuss a lot of these. But in order to make sure that you touch every base, I thought the thing to do would be just read it section by section by section.
Okay. Okay. If we start with Section A, then, as a group, one of the things that we could do to clarify this, any business or financial transaction, maybe, here, would clarify that we're talking about financial interests. Or other financial or other private financial interest? I mean, so how should we, what's the best way to include that is really my question here in this language, to make it really clear that we're not talking about, that the conflict of interest as defined by the charter is a financial interest, and this should be an expansion upon an explanation of what the charter limitations are?
Have we, a question for Bob Sullivan, have we ever had a conflict of interest complaint or case that was not financial?
Not that I remember. It all involved money one way or another. As you know, we did have a case 2 years ago where it was not under this provision of the ordinance, but, you know, where a later provision of the ethics ordinance was implicated. But even that involved money, so I guess...
Yes, it was a transaction.
Yeah.
Yeah.
So I guess the answer is no, we've never had a conflict of interest case where, I don't know, somebody took a city truck or something and used it for their personal business. I don't remember anything like that. I will make the general observation that the city's record on these things is really very good. You know, you read in the newspaper what happens in other municipalities and other places, and those things don't happen here. This is a pretty good operation.
Yeah. Yeah, and I mean, the state statute is about financial. We're allowed by the state statute to add potential conflicts that we see, but, you know,
Right, and of course,
it's
this
not
is...
broken, you know.
You know, we discussed that when we started in on this topic how complicated this was going to be, and it is. And and your comment that you just made really brings up that there's different standards that would apply to an elected official, such as yourselves, an appointed official in a high administrative position, such as a department head, or a city employee who would most likely be a member of a union. So they all do different things in different ways and serve in different capacities. You, for example, are legislators, whereas an appointed city official like a member of the zoning board, for example, is held to a wholly different standard than you are in terms of your conduct. You have much more latitude than a quasi-judicial board member, for example. So, and yet, the way the ordinance is written now, that provision you're reading isn't. It purports to apply to everybody. So, it's already kind of complicated.
Can I ask, legally, some of the language that I struggle with here, shall have a financial or other private interest. What is it? The other private interest besides that?
You know, it might be, let's say, that a city official had his or her driveway plowed by the Public Works Department.
Isn't that also, though, a financial interest?
It is, although not directly financed, not. Sometimes when, at the council level, when we've talked about how to apply these standards, direct pecuniary interest, what I've said in the past is, to councilors, is if a decision that you make on the city council puts money into your pocket or takes money out of your pocket, then that's a decision you should not participate in as a councilor, because you violate the state statute and also local ordinance. If the public works employee has a truck plow his or her driveway, it doesn't directly put money in or out of her pocket, but it's getting pretty close to it. So.
What about a possible scenario where there's an elected official, the elected official's brother owns a lot of property, and there's a vote about short-term rentals, for example. Does the elected official have a private interest since a direct relative of his is affected by that?
I think to take the highest standard, the answer would obviously be yes. But the way the ordinance reads now, it would not be a violation of the ethics ordinance.
And in this, we don't really clarify family,
Yeah.
and maybe we need to do so, because I think that is clarified for our quasi-judicial boards, but it's not clear here in our ordinance what family
Okay.
stands for.
This is Clarence Thomas.
Yeah.
Yeah. So maybe we need to include a definition of how far this extends, to what family members.
Yeah, I know Concord's does include family, and they limit that to spouse, mother, father, stepmother, stepfather, foster mother, foster father, father-in-law, mother-in-law, grandmother, grandfather, grandchild, sister, brother, stepchild, basically grandparents, kids, siblings, spouse. Not siblings, I'm sorry.
Not siblings.
So that would call for a pretty significant rewriting of what we have. It would have to be something like a officer employee shall not participate in any item of city business in which a mother, father, brother, sister, spouse has any interest.
Right. Well, what they say is they would just add the person or a family member of the person, and then they have a separate
define
paragraph
family somewhere
defining
else.
family.
Is that a necessary thing?
No, the thing, something we discussed already is, this is a city, but it's not New York City, and pretty much anybody who has a substantial number of family members in their community is going to have situations where things that they would do in their official capacity affect those family members. And so that's, your decision you have to make.
I think the challenge here, though, is the way it's currently written. Say my husband owned a business in a particular area, which he does not, but if, say he did, but I had no share in the business. He owned it with business partners. And we were making a decision that would directly benefit that area and 3 or 4 businesses that sat there, including my husband's. Right now, there is no reason in the conflict of interest for me to recuse, because that's not included, and I don't own a financial interest in it. But clearly, I would benefit very directly, or at least there's an assumption I would benefit, assuming our finances are commingled and not separate, that I would benefit directly.
But the business would not be commingled.
Right, exactly.
So that's,
Maybe this will speed things up a little bit. If the committee will decide the result that it wants to see on each of these,
Right.
then I'll write the actual language and bring it back to you. Because if we start trying to figure out the actual language here at the committee level, we will not finish even going through this ordinance by the end of the council term.
Point
Wise-
taken.
Wise warning.
is that commentary on committee work?
That's great. So I don't know about the rest of the committee, but I would love to see some clarity in Section A around what it's just really nebulous about what exactly we're talking about. And probably a preamble to go with this. Because when we don't make any definition of what a private interest is, there's a lot of assumptions that go into play there. And it depends on who's reading it.
Right. And I have some preamble language from other ordinances that I could give to Bob.
Great.
So shall I take, that's 2 of the 3 committee members, so should I take that as your first recommendation for a change in the ordinance?
Defining,
I was going to say, the first one would be add a preamble.
yeah,
And add a definition section.
Add a definition section, yes.
meaning private interest.
Yes. So we define private interests.
That's a good way to do it, yeah.
Define personal, I guess,
Well, I'd say-
personal interest to the extent how it relates to family.
Yep.
Right.
Yeah, I mean, I think that all falls under private interest.
Yeah.
Okay, I got those 2.
Okay.
And that's repeated in a lot of these
Yes.
sections.
If everyone's comfortable going to Section B, I think Section B is even more confusing, and there are stories behind this and how people don't feel comfortable serving or running for office because they represent, especially attorneys, because they have a tendency to represent clients, or their firms represent clients that come before our land use boards in particular. If you ever deal with individuals within the city, and that makes this incredibly complicated, representing private interests before city agencies.
There's a history behind this section. There was a time when it was very common to have a significant number of lawyers on the city council, and I know this included Bill Scott was on the council one time, John Mayer was on the council one time. There were others of that generation. And they were all required to get off the city council by a change in bar association ethics rules, which, because the council appointed members of the zoning board, for example, they could not be on the council and appear in front of the zoning board. And so it deprived the city of all those lawyers. And what happened was that the Bar Association actually loosened its rules so that it would be possible to have some lawyers on now. But they never came back in the numbers they used to serve.
You know, I can understand. I think that the reasoning here is sound in including this passage about not representing private interests before a governing body or a land use body, because the conflict is created when that body knows your position and knows you're an elected official and that you have the authority to appoint them or not reappoint them. And so when you appear before them, it creates that unnecessary tension that probably should not exist.
Yeah, and I would see the potential conflict between being an elected official and pursuing a policy direction, and also having to serve a client, and serve a client in a way that's contrary to the policy direction. And that would be an untenable situation.
I guess the question I have is, can an elected official also be just a resident? Where does that line fall?
This is, I think, where we need clarity. And I think this is one of the real challenges here. I would be more stringent with this rule personally. I think that individuals should be allowed to appear if it is before another body, say a city councilor should be able to appear before zoning or planning or the HDC if they are representing their own interest in a case involving a direct abutter.
The specific lawyer problem that I talked about was that if a lawyer was a member of the governing body, a member of the city council, who appointed members of the planning board or the board of adjustment, then no member of that lawyer's law firm could appear in front of the board of adjustment or the planning board. And that's,
Wow.
so that cost everybody too much business, that nobody could be on the council if they did that. And that's the kind of thing that will come up here. I think if you're on the city council right now, you don't lose all of your rights as a citizen or a resident or a property owner. So you can still do those things, appear in front of the zoning board on your own behalf, for example. But what you can't do is take an action as a city council member with regard to those things.
Right.
So you recuse yourself from anything that comes before the council, but not something that comes before the zoning board.
And I would take it another step to say that you can't speak to those boards unless you have you're a direct abutter or it's regarding your own property, because it creates that tension and that conflict.
Yeah, I think this is your decision to make and recommend as you see appropriate.
Well, it's certainly good so far as it goes. The question is whether to go further.
Right, exactly. And I would just push it that step further, just because I think that right now we don't have protections for those boards in having to deal with council members. You don't want council members trying to influence the work of quasi-judicial boards. I think that's a problem unless, they're actually a member of that board, because it does create that, especially if you're talking about a board like the planning board right now, where you have a city councilor already sitting. So then if you have another city councilor come to speak to an issue before the planning board, or two, suddenly you have 3 individuals sitting there speaking to an issue that, if they're not a direct abutter,
Right.
for example, they're coming just to speak to something they're concerned about, you already know that you have 3 individuals that you're questioning. If you don't vote with their concerns, are you going to get reappointed to that board? And I think that that's an unfair standard, because it calls into question their decision-making, I think.
Yeah. It's something that would weigh on the mind of a ZBA or planning board member, potentially. But on the other hand, how do you protect a city councilor's right or a planning board member's right if they want to go to the ZBA to put a deck on the back of their house?
Right.
You know?
And that's where I think that we should be really clear that if it's about your property or you're a direct abutter, and that would be the state definition of abutter here, I think, because the state definition is much more stringent than ours.
The local definition for zoning purposes is broader than the state definition. Extending, I forget the exact number of feet from the property line, but it's different than direct abutters. It's broader.
Right. Yeah, and the challenge is in a neighborhood like mine is then I could just still speak to about anything because I get notices for quite a few blocks surrounding my home. So you wouldn't want to use that standard. You want to use more of a direct abutter standard, I would think, or a individual standard. At least that's in my view. A way to tighten this and for it to be much more clear, I think. Plus, I think we should also be clear about what the standards are here, and this may come in later, because the quasi-judicial boards have much tighter standards, of which they're advised at the beginning of their terms and at the beginning of every year, that maybe we should make sure we include that here so that it's clear for everyone what those standards are. Because I think people our residents get confused about what the difference is in those standards.
Right.
So,
That's right. But briefly, the legislative standard, the one that will apply to you as councilors, is that you should not participate in matters in which you have a direct pecuniary interest. Pretty broad standard, allows you to talk about a lot of things, and that's consistent with the idea that councilors are actually elected because of their viewpoints on issues, and therefore you should be able to express those. The general standard that applies to the judicial board members, planning board, zoning board, is the so-called jury standard, which is basically any interest that would suggest that you might have some bias one way or another going into an issue. And this, even without you listing specifically family members, for example, any involvement of any family member in any way in a matter that comes before you or someone in a judicial capacity, that person should not participate.
right.
Yeah, anything that, prevents you from being impartial and independent-minded.
Yes.
Right. Whereas council members would not be restricted from speaking on matters that are related to decisions that the zoning board or planning board are making, just not before them.
Here's the problem, and that is, as a board member of a land use board, if city councilors come before them and push a point, that puts that board member in a position of, well, am I going to get reappointed? So does that create a conflict of interest for the board member?
Well, of course, you have experience in these things.
Yeah, I sure do.
And can probably have a more in-depth viewpoint than any of us. But the issue before you now is, do you want to recommend some change in this ethics ordinance?
Yeah, I don't know.
Yeah.
I don't know what they would be.
Yeah.
Well, I would support where Councilor Cook is going, that we should say, we should prevent even elected officials from appearing before land use boards unless it's related to them as an abutter or a property owner.
I don't know.
What is that?
You're a representative, legislative representative of people in the city. Do you think that you should be barred from speaking in front of the planning board on a major public issue? Should the zoning ordinance be changed to allow a particular building downtown or downtown area to have a greater height in buildings, for example? It seems to me it's pretty legitimate for a councilor to weigh in on that. But that would be prohibited by the...
Right. And that's the question we're wrestling with. So I sort of lunged at that. But let's think it through.
Yeah, the remedy there is for the council to take up the zoning ordinance, not for the council to speak to particular projects that are before planning, but rather to change the zoning ordinance at the council level for everyone. Because you can't do spot zoning. So, in essence, a councilor speaking to an issue before planning to change zoning for a particular project is recommending spot zoning, essentially.
Maybe. Spot zoning itself is a judgment call.
It's a hard one.
Yeah, this is what I remember.
And-
When we started on this, I said,
It's
Good luck.
tough. But to me, this is where we clearly delineate the difference between being quasi-judicial and being legislative, is that legislative boards make the overall broad rules that everyone else follows. And then we rely on our quasi-judicial boards to implement those rules. And if we're unhappy with the way the quasi-judicial boards are implementing those rules, then we appoint new members to the quasi-judicial boards, rather than going before them and telling them that they're making poor decisions, because that influences,
Yeah.
that crosses that line between legislative and quasi-judicial, because they have a different standard.
Yeah.
Yeah.
but Councilor Tabor's suggestion was that elected officials not be allowed to participate in matters before the regulatory boards unless they were directly involved, that was their property.
Right,
I'm
but
not
when I
sure.
frame, yeah, when we try that out, test drive it, it seems quite restrictive. I mean, we are taking away an elected official's rights as a citizen.
But that elected official can bring changes directly to the council
Right.
as well. And so, in some ways, going to the boards is making an in run around the council process, too. Because if you really want that change, you could come to the council, and if the council agrees with you, the change will happen. But if you can't get the change at the council politically, then to go to the land use board to try to make the change, you're also ignoring the will of the majority of residents.
These issues can cross over all the time. A sophisticated real estate developer with big projects, what I've seen occasionally in the past is simultaneously they question the administrative decision of the planning department. You're wrong, I don't need that approval. At the same time, they go to the zoning board of adjustment saying, gee, if that planning official was right, then I want a variance from the ordinance. And then the third thing, at the same time, is request the city council to amend the ordinance so the thing they want to do is allowed. So these things can just all commingle and cross over.
And they hire a PR firm to,
Right. But if the city wants to avoid legal entanglements, it's probably best that the several do not mix in their conversations.
I just don't know how you write this to accommodate all those situations? And, or if you can, or if it is even a good policy to do that, what, maybe a better way to deal with it is to look at it on these situations on a case-by-case.
The only problem with looking at everything on a case-by-case basis is that's having no standard at all.
Yeah.
Yeah.
So if we moved ahead with language, and in spite of that language, an elected official, a city councilor, went and made an impassioned speech to a land use board, what would be the sanction?
Yeah,
Referral to the ethics board,
Yeah,
yeah,
for violation of the written policy.
right.
And then that process would kick off and a sanction would be recommended.
Right.
I think that this is just my view now, I think that elected officials who run for office periodically should be given more latitude to operate than employed officials or appointed board members, because the check and balance to make sure that the elected official doesn't do anything wrong, doesn't act in their own benefit rather than the city's is, they won't get elected next time. So my thought is, when it comes to councilors on this kind of stuff, I actually think you don't have to stray too far from you shouldn't act in where you have a direct pecuniary interest. It seems to have worked generally. I mean, other than a few celebrated cases, there actually has not been a lot of problems with this over the 40 years that I know about.
Yeah, you know, there's a lot of municipal ethics ordinances, and some of the ones I like are more directly tied to pecuniary, to money.
So basically what you're saying is that if it's not broke, don't fix it?
Yeah, this is basically what I'm saying. Yeah,
I would contend that it is broken.
well, then it
And
needs to
that
be fixed.
we have seen counselors speak to issues before land use boards. And I would say that that does exert undue influence. And we need to be very careful around that, especially when we require the quasi-judicial boards. We hold them to a very high standard. We need to make sure that's included here as well, so that people understand that standard, that they cannot come and speak to things before the council that are before land use boards or decisions made by land use boards. That it's really clear that the councilors are also not doing the same thing. That, you know, when we hold them to a really high standard and they're all volunteers, we need to be really clear about what the standards are for legislative officials. I just feel like the standards aren't very clear here either.
So,
Does that give you guidance?
no, I was going to say, in order to recap, here's where we are so far.
Do you have a blank page there?
No, I'm going to propose for you a preamble to the whole ethics ordinance. We're going to add either a definition section or included in an appropriate location definitions of the term private interest and family. And that's what I have so far as instructions from you.
Right.
Okay.
And then we're wrestling with representing private interests before city agencies. And that's, that's a matter of degree, right? If a elected official makes one appearance, gives his input, her input, and sits down. But if it's a continued presence, I think the continued presence and more than one, that's a little daunting. I mean, if in pursuing a sort of philosophical approach. So, I hear what our former city attorney is saying. The remedy, since keep things broad and for elected officials because their actions are always subject to the voters every 2 years. So that's it's a tricky one.
It is. I think
it-
it's tricky, yeah. But they also have another remedy, which is, if you're unhappy with zoning, you can change it. So,
Right.
If you're a member of the legislative body, you can put forward changes.
Yeah, and it's almost unfair to blame the planning board, which their job is to interpret the zoning that's on the books
Right.
and apply it. So, if you want to remedy how
Well,
things
to
are
make
being
things
built.
a little more complicated, zoning board virtually always acts in a quasi-judicial capacity. That's pretty much all the zoning board does. Things come in front of them and they apply some facts they find to the rules that exist. Planning board, while it's acting in a quasi-judicial capacity on a site plan or on a subdivision plan, the planning board also has a substantial legislative role. And you've just really listed one. When the city council refers a rezoning, which they're obligated to do, refers a rezoning request to the planning board, then the planning board, when it looks at a rezoning request, is acting in a legislative capacity, not quasi-judicial, when it makes its recommendation to the city council. So it's really difficult to, it seems to me that's a totally different ethical role in two different situations, both of which go to the same board. So.
Well, and I think that there are challenges there as well. So say the city council recommends a change to the zoning board, and there were 2 dissenters at the city council, and those 2 dissenters come to the zoning board and speak passionately against the change.
Yeah.
Then you get misrepresentation, and the zoning board is there with a recommendation from the council, but only dissenting voices before them, which I think, again, is exerting undue influence because you're sitting there in your capacity as a zoning board member and say your appointment's coming up. If you vote against this, you've lost these 2 votes already.
All right.
So how do you make that call? So that's always my concern, is not creating undue conflict where there is none. If no one gets out of their lane, there is no conflict created. It's already difficult enough, I think, for our quasi-judicial boards to make decisions around when you own a property or you're a direct abutter to a property and you're coming to speak. Because they probably also feel some conflict there as well if they don't agree with what you're speaking to. But you have that right because you own the property or you're a direct abutter. But then to ask them on issues that are not related to something that you own or you abut directly, I think you could have potentially, and I don't know if this has ever happened in the city, you could have somebody who sits on the council who just goes to every single meeting and speaks to every single issue in one way or another. And then it makes it really clear to those members when they vote, whether or not that person would vote to reappoint them. I think that that's unfortunate. But that's currently allowed,
Yes.
technically within the law. I think that there also there's a second aspect here that we need to clarify. Representing private interests before city agencies is not fully clear about whether or not you can represent yourself. Even though we've never had a problem in allowing individuals who are sit on boards or sit on the council to represent themselves, it's not clear that you're allowed to fully in the language. We need to make it clear that we're actually allowed to represent ourselves in our
Right.
disputes around our property.
Right, and we certainly want to preserve that right.
Yes.
On their own behalf.
Yes.
Well, the way I'm reading this section now, it would prohibit a counselor from being paid to appear in front of the zoning board on behalf of somebody. So this is that lawyer problem we talked about.
Yep.
It would not prohibit the counselor from appearing in front of the same board for the same person if they weren't being paid. Because that's performance of their civic obligation, their duty as a counselor.
And what I'm saying is that I think that needs to be clarified for everyone who's reading it, who isn't an attorney, and so isn't reading it like an attorney. I think clear language always benefits us here.
I'd certainly be happy to write clarification language if you tell me the result you want to have.
That's what we're trying to figure out.
So maybe this is one we should come back to. I think that we can all think
Yeah,
about it.
and maybe do some reading and
Yep. Yep. I think we all have kind of nuanced views here. Mine are probably a little bit more strict. But we can come back and talk about this at our next meeting,
Right.
Section B.
right.
Section C, representing private interests before courts. And I want to be mindful of the time. We have very limited time today, so, and I want to make sure that we get to appointments ordinance, even if it's a short discussion. Section C, representing private interests before courts.
This seems clear to me.
So, I mean, this is, basically, you can't represent a private interest in the court. It would apply mostly to attorneys, currently, the way it's written. I do have questions about whether or not you can, serving in a legislative capacity, if you're in the process of suing the city. And that's something that we haven't ever covered. Or if you can serve on a land use board if you're currently suing a land use board.
Those two don't play well together, that's for sure.
No. No, I mean, it's a challenge. If you're suing the city and then issues become before the council, for which you're suing the city, you automatically would have to recuse yourself, I would think.
Right. And that's not the case now.
Right.
So,
And so maybe that needs to be really, really clear, that if you're party to a lawsuit before the city, you have to recuse yourself from discussion around that.
Yeah, and do we even, what happens when you go down the road of an elected official suing the city? Not only does that person, they should give up their right to talk about that issue in a legislative capacity. Well, I suppose it's up to the voters
Right.
at the end.
Well, we can say it's up to the voters, but can somebody who's suing the city sit in on discussions of the council about the defense against that case? If they're the plaintiff?
I mean, that's,
It is not unheard of in the world.
I was going to say.
Yeah. That's where I think we need to be really clear here. That is not prohibited. And it would be a direct conflict for them to sit in on defense discussions with legal.
Yeah, that would be obvious.
I mean, you can't prevent somebody from running for office, and you can't, I mean, we could, but, somebody might run for office because of a problem they've had with the city.
Sure.
But it's one thing to have them sitting on the council, it's another thing to have them in discussions on cases defending the city when they're the plaintiff.
I suppose the narrow view that you might recommend is that no elected official who's participating in litigation against the city should participate as a city official in connection with that matter. So there's kind of one side of it.
That's,
And the other side would be no elected official who's engaged in litigation with the city should participate in fill in the blanks, but anything.
I personally would like to see that clarification here.
I find that the wording in C is a little, I don't know, arcane maybe. It's just, it's not, it doesn't describe really what I think. Maybe it does to the lawyers or something, but it doesn't to me.
So even though we're on item C, we're actually talking about quite a bit broader policy here. Item C would, as you pointed out, basically just apply to lawyers. But what we've been talking about the last few minutes is no elected official has engaged in litigation against the city, or no public official who's engaged in litigation against the city. I mean, somebody well beyond lawyers
Yeah.
should participate in something.
Is this not already the standard for quasi-judicial board members?
It is.
That's what I thought. So,
If it is, if you limit it to, they can't have any involvement in the item before the board. If you wanted to recommend they not be involved in anything, if they have an action against the city, then you might be expanding it beyond the state,
right.
which you have a right to do if you feel that's the good policy.
Okay.
well, here's as a straw man maybe. The outcomes we want are none of our officers representing private interests before the courts. And second, if one of our officers is suing the city, that officer does not participate in any discussion, public or private. And then the question would be, would you want to go further? Is that sensible?
I
I
think
mean, is that the direction we want to go, the three of us?
it's already a little higher standard than we have.
Right.
So it would definitely be an improvement. I don't know if it goes far enough, but I'm really strict on these rules. I would just say you can't run for office. That would be my standard, though, that, I would never think it's appropriate to run for office if I was suing the city.
Well,
Let me
what
just-
if you're in office?
Well,
Should you be removed? That's
Right.
Let me just throw out something that's not controversial but could happen. A simple slip and fall, in which, now we're insured by a third party, Primex, well, it's a member agreement, so.
Right.
But there might be an occasion where someone might have a perfectly legitimate slip and fall case that is simply taking time to resolve, that maybe there's a dispute on damages that winds up sort of following the litigation path. So nothing, something that happens. We have a number of slip and fall cases that get resolved one way or the other through a process that sometimes takes a longer period of time. Having that person who's an elected official, a board member or whatever, not participate in a discussion about, oh, should we settle, authorize settlement of this claim for a certain amount, you wouldn't want them to be part of that discussion. On the other hand, would you want that to preclude someone who otherwise may have just a dispute that has its strengths and weaknesses and merits? So I just put out there a non-controversial, relatively non-controversial things where that might come up. So, there's a gamut, obviously. So, I don't know.
These things happen. When Eileen Foley was mayor, she was on the elevator one day, and the elevator, as it got to the 4th floor, stopped an inch or two short. So that when she attempted to walk out of the elevator, she tripped on the edge where the floor began, the elevator ended, and fell and broke her collarbone. So it happens. Exactly the situation that Suzanne just mentioned. So, to what extent?
So it's a issue of degree then.
Well, she would, yeah.
Yeah, I mean, basically what we're saying is what qualifies then?
Well, we didn't have to face the issue in her case, even though it was obvious city negligence and serious injury, because what she said at the time was, my mother was the mayor of this city, I'm the mayor of this city, my daughter works for this city, my son works for this city. She says, I don't care what the fault of the liability is, nobody's making any claims against anybody here.
That's Eileen.
But you can see how that should obviously be, something like that should obviously be excluded. And so it may be reasonable to have the standard that you can't discuss things that are you can't be a part of the discussions around anything for which you have a dispute with the city, a legal dispute with the city. So
Well,
you're excluded from that.
let's take another for instance. What if the council's discussing something and, let's take the Goodwin case, for example.
Why not?
Why not?
Well, and they start to have non-public settlement discussions. And a counselor says, I don't think, the counselor wants to blow the whistle on that, and sues under Freedom of Information Act. That counselor may be arguably, in the light of what everybody learns later on, in the right to blow the whistle. So, if we're talking about more extreme language where there'd be sanctions for suing the city for an elected official, that would be a high cost for blowing the whistle.
Yeah. So
Or maybe a elected official is a source for a newspaper reporter. And,
This certainly happens.
Yeah, that certainly happens.
So maybe we want to make sure that we limit it. We include it, but we limit it to cases in which you're actively suing the city. You cannot participate in discussions around those with, like, the council or you recuse yourself. You're required to recuse. If you're actively the plaintiff in a case.
Even if it's a whistleblower case.
Well, you shouldn't be able to discuss with the, so what I keep coming back to is if the council is discussing with their attorney how to defend against that case, the plaintiff should not be sitting in the room because it violates attorney-client privilege.
Yeah. Yeah.
And so that's the standard I would put in it, is making sure that they stay in their lane
Right.
and that they're recused from voting on that issue. Because they're not representing the city in their elected capacity. They would be representing themselves. I think that's all the distinctions here are, if you're representing your personal interests, you're not representing the city or the residents of the city. And so to me, that's the clear distinction here, is just making sure people are not taking advantage of a loophole. Even if we haven't seen it happen, we want to make sure it doesn't happen.
Yeah, I'm just thinking through permutations, I guess. And,
Well, of course, Section A of this provision that we've already talked about, and we talked about last meeting as well, as ambiguous as it is and fraught with issues of interpretation as it is, or as it does, would, at least one reading of it, would cover the situation that Councilor Cook has just listed. But it could be more clear.
I wouldn't want to deal with that challenge in court on the part of the city, that was actually covered. If someone was then accused of conflict of interest based upon provision A because they were part of a lawsuit, and that was not spelled out, I would not want to be trying to defend this ordinance as saying that in court.
So isn't it something as simple as no elected official who is a plaintiff against the city should participate in their official capacity in discussion or decisions relative to that same action? Something.
that sounds good.
I mean,
Yes.
Bob could massage that, but I mean, that's,
Yes.
Yeah.
Yes.
Why don't we take a shot at that?
I put it in the draft minutes.
And, and the question I have is that, since this already applies to quasi-judicial boards, do we just say that it's not just for elected officials, it's pretty much for anyone representing? I mean, I think it's the same standard for anyone.
So officers.
Officers, yeah,
Goes back to that definition of terms at the beginning.
Right.
To maybe.
right.
Right.
Does everyone feel comfortable discussing D here for a few minutes? I think that D is pretty clear personally.
Yes.
The nature and extent of such interest. Yeah.
That you just disclose in advance of discussion.
It seems pretty clear. It serves an obvious purpose. It helps maintain the system the way it's supposed to work. Legislators can act in a legislative capacity, but if they have some interest, they have to disclose it so that not only the other councilors will know that there's more than just a city interest at stake here, but there's voters at the next election will know the same thing.
And I've had the discussion with our former city attorney that I would love to see a disclosure form that's filed, so that everybody discloses all their interests as far as board service or financial interests in real estate within the city, at least once a year, or discloses it, and then if there's change, you disclose it. I think that that's something that Thomas Neese suggested to us.
Yeah.
Because they publish their disclosures online, and it would be great if we had a form to disclose all of these things. Then they would be really, really clear. The clerk would have it on file. Anybody could access it.
So you're saying board's ability for an organization.
Right. If you're serving on the board. And the reason that I say that this is important is that that's the kind of thing that not everybody would know if you haven't disclosed it. They wouldn't necessarily know what your interests are within the city. So you could have a city councilor voting on things related to their private interest, you could say, but that nobody even knows that they have a private interest there because they've actually never disclosed it, and it just isn't very public. So I think it's important. This is just, to me, an important step in making sure that the public is more confident.
Yes.
So as a disclosure, but not as a requirement to recuse.
Correct.
This is, who was it, Felix Frankfurter who said this? Sunshine is the greatest disinfection.
Yes.
Disinfectant. The mere disclosure solves the problem. Because people understand. what's
And a consequence of that is that it will be printed in the media,
Yes.
which, philosophically, of course, I'm okay with. But that's,
Okay.
it's- that's a consequence.
So it would seem that no changes really are being
E is
requested
good.
in section D or E.
Well, except more of a disclosure form.
Yeah.
Yeah.
To include a disclosure form, and you recommended annual.
Yeah.
So each one says that the persons involved, councilors or officers or employees, shall publicly disclose on the official records. Is the thought require a written disclosure on a form?
I think that's what I'm suggesting, is that we have a written disclosure form so that it's really clear for everyone. And I think that was what Thomas Neese was suggesting to us at our last meeting, because they actually published theirs. But I think this is something that you could just add the word written publicly,
Okay.
somewhere, and then the clerk can keep the forms, the way the clerk keeps the other filings around that, so.
So if that's the will of two of you, then I'll write that for the next.
Yeah, I think that's.
No, let's try it out and see what language we get.
Yeah.
Okay. Ooh, the next one.
Gifts and favors.
Yeah,
Yeah, this is
well, yeah. This is a challenge, because this was written so long ago. And I think that the $100 standard was created, in my understanding, to allow for staff, because employees are included here, to do things like go to a conference and the city pay for their conference attendance, or pay for, if you're going out of town, pay for your hotel, or pay for, but we all know $100 is not,
Doesn't cover it.
doesn't cut it anymore. So the question is that how much of that information do we want disclosed? Because essentially this would require disclosure. But in practice, what has happened is it doesn't require disclosure. What we've done as a practice, especially for employees, is they just turn it down. So that seems to be the common practice, is that the answer is no, rather than we're going to disclose it. So So the question I have here is making sure that we have language that allows for training and education, continuing training and education for employees and staff, or even for, you think of quasi-judicial boards, if you want to send them to a conference, New Hampshire Municipal Association conference, and you want to make sure that they get that training, but you don't want that to be excluded as part of gifts, or for them to feel like they're going to be somehow in trouble with the conflict of interest policy because they're getting that additional training.
Well, the language here is about gift from a non-city third party.
Right.
Right, but in some cases, you can, the registration, they'll say the registration, which is valued at X price, is going to be waived because you're a city employee. You are still receiving that gift of registration. And say the registration is $120. You would have to turn it down.
Right.
I think that's the concern, is maybe making sure that the language allows for, and then we can decide how much we want disclosed or not disclosed. You know, you don't want them necessarily to be accepting personal gifts over a certain value, but you want them to be able to accept intangibles, like around education. But then, you know, what are our disclosure standards for that? You know, do we just make sure all officers or employees disclose those? I received conference registration from the New Hampshire Municipal Association that was valued at X, you know, on this date. And just make sure that that's filed somewhere where it's accessible.
So TEDx, I mean, that was $75, but that was a gift from them, I presume. And then a discounted ticket, in addition, brings it closer to 100, but, you know, it's, I can imagine, you know, the events that the chamber puts on. You know, they charge other people, but the council goes, you know, is invited. How does that work?
So I would concur that to the extent that sometimes we, the municipality itself pays for board members or others or city staff to get training, I think what I'm hearing, and I appreciate the sensitivity because prices have increased, particularly over the last few years, is that when there's an opportunity to get a waiver of a fee to attend a conference, or even an arts event, frankly, the question is there some amount beyond the $100 that, as long as it were disclosed and maybe had the approval of the, if it's an employee, the approval of the city manager or some other mechanism, I don't have the answer right now, that because of the increase in cost, there are opportunities that might be useful for some folks to attend because we otherwise don't have it in our budget. I know I have certainly gone to, well, some years ago now, a American Bar Association construction conference because I was getting an update on certain forms that are used within the industry, and I applied for and received a scholarship for that. And so not all the fees were waived, but that's kind of, it's in that kind of weird zone of where does that fall, because it certainly wasn't a gift. It facilitated and frankly saved the city some money on my attendance. But, you know, there are other opportunities that fall in that zone of it's definitely related to work, but might be some benefit from a third party because they recognize that municipalities and government entities don't always have the same funds that the, you know, private construction companies that were sending their lawyers to these types of conferences, you know, couldn't, you know, pay the same level of fees, so you get a discounted rate. I think what is helpful is a lot of in those contexts, it's a discounted rate for all government officials, so it's not special to one particular entity. But I do think we're seeing there may be opportunities that would be, useful to avail ourselves that might fall over the 100, but have that educational piece that, if disclosed and approved, might be of use and value.
And I see, I see this as, from sitting on the Arts and Nonprofits Committee and having Sean Clancy, our Economic Development Director, sit there. I want him to attend arts events in the city. I want him to be able to accept tickets to arts events, because then he becomes an ambassador for the arts for the city. And that's part of his role in sitting on that committee. And so I don't want him to be in a position that he says, no, I can't take those tickets, but also can't attend then anything within the city when his job is dependent upon knowing what we do in the arts community. So that's the kind of thing that I'm thinking about. The changes in pricing are pretty significant in the last 40 years since this was passed. So I just want to be mindful that we're not automatically excluding staff from attending. Or officers. I think about, I really do think about, special training opportunities that we have specifically around land use. I want to make sure that they have those opportunities.
Well, just to play devil's advocate, let's say that school board members are offered, or school officials are offered curriculum training, but it's curriculum training from a particular point of view. And they say, we'll give it to you for free. If the existing ordinance existed, there'd have to be a request for a waiver for that, which would be some oversight. So are we allowing our employees to be lured into free educational programs that may not align with the policies of the city or the elected body? Or I'm just throwing out hypotheticals.
I think that's really up for the city manager and the department heads, to review and evaluate what is an appropriate use of a city employee's time. I think if it, frankly, we're all pretty busy. And if we don't see it fitting within what is going to actually be useful and conducive, which sometimes actually going to an event and meeting people within that industry can be really
Very
useful in
Very useful.
doing your job. So I'd like to think that you hire, the city manager, make sure you have professional staff that have the ability to understand the city council's goals and the city manager's direction, and could, work within their departments to, separate the wheat from the chaff, so to speak.
And when it comes to elected officials, that is they get to make those calls on what's
Right.
valuable and what's not valuable to them as an elected official, right?
Yeah.
So I guess my question here is, right now there isn't a waiver option. So
That would be true.
do we include a waiver option, or do we just include a disclosure option? Or do we change the financial figure? Because of it's been 40 years since this was written. Like, how do we
Yeah, I noticed
address that and make it, bring it up to modern standards?
Some other cities I've looked at are 250. I don't know how that arrived at that figure. I don't know if that's a place to land or not.
Pulled out of the air, I'm sure.
You know,
In a sentence, I think what this provision is intended to prevent is city officials being bribed. But at the same time, recognizing that a small gift or lunch or is acceptable and it's not, there's no evil connected with it. It's not a bribe. So,
so maybe we can go back and think about this. Think about come back to our next meeting and think about, do we raise the dollar total or do we not? Or do we just insert a waiver option here?
Yeah.
Or do we do both? Or how do we exactly want to address that? I would also argue that the last sentence, this provision shall not apply to campaign contributions of $100 or less. We should strike that. And the reason I say that is we have a separate provision on campaign contributions, and I think it makes it
Confuses
confusing.
this.
Yes, here.
Yeah, I agree.
Where we can
I was gonna
include that.
bring that up.
Yeah, we can include that later, I think, so, in
This
the
is
other
just
provisions.
consistent with campaign contributions, and maybe that's why it's there, but
Yeah. Anytime we can create clarity is a good thing.
yeah. And I almost think that a waiver is maybe a better process than trying to adjust the value, because the value is just going to constantly change. And maybe in a policy, we did determine a value rather than in the ordinance. A waiver policy or something like that.
It might be a good alternative.
Yeah.
Yeah. I know that Counselor Tabor has a conflict here in a few minutes and has to leave.
Yeah.
So what I'm going to suggest now is that we skip over our second item under old business, administrative ordinance, and postpone that until our next governance committee discussion, so that we can go to we can wrap up the discussion here we're having today and come back to it at our next meeting, and go ahead and have public comment, so that Counselor Tabor can get to his next meeting.
I'm sorry, I do have a hard stop. today.
That's fine. That's fine. It happens. We run long anyway here in governance, so it's completely reasonable, but
We got to letter F. That's pretty good.
pretty good.
so in order to keep things moving, what I would suggest is I will take the items you've discussed under this section as far as you've gotten, and I'll give you new language to
Great.
meet your request for the next meeting.
Thank you.
And then when you get to the other parts, we'll write those down.
Right.
Very good. Thank you. With that said, I'm going to go ahead and open us up for public comment. Does anyone want to come and speak?
My apologies, Peter, but I do have to be somewhere at 11:30.
Sure, John.
I'll watch the tape.
Peter Huda, 280 South Street. So, the first thing that, in this whole discussion that I'd like to, I guess, caution you on, is the adjustments you're attempting to make to the administrative code do not conflict, especially with the officers and employees on elections with Section 3.1 and all of Section 3. Some of the discussion that was here, you're looking at tenure of office, you're looking at qualifications, you're looking at politics, and oath of office. That a lot of this defines this, so, and I'm sure Bob is aware, the process to change the charter is a lot different than the process here. And if you have overlay or a problem with that, just something to bring up. I'm going to go backwards in my comments because the last one is still on my mind. The attempt, or whatever you want to do to change the amounts that are classified as a gift, I guess I would remind you that we budget for all this. It's under training in almost every cost center. So if you're worried about, for example, employees going and getting training and keeping up on their qualifications for their jobs specifically, and I would relate to finance, they really need to do that, and that is already in the budget. There is also money in the budget for the city councilors, and the mayor has his own little cost center himself. So on that, I got the feeling you were kind of mixing these, so I would just like to call that to your attention for your consideration. Going back a little further, as a person who's gone through the process of running for council and have had to disclose all the information, I mean, the person who's running should be obligated to do that. The discussion here about going back to grandparents and everything, whoa, sorry. That's a little on the extreme side. The other point I would make is I know that your last speaker, I think Tom Neese, brought forward that a lot of this stuff should be put out online. I think you need to be really careful about an invasion of privacy and the data that you're putting out there, especially for, and I'm definitely careful about this, especially for, any kind of data that could be connected, that you could have somebody take your data, steal your data and your identity. So I think that should be a consideration out there. Going back to your discussion on planning boards and zoning boards, the thing I guess to remember here is, as a council, I do believe you can request an ordinance change for the planning board and the zoning board, but I don't know how far you can actually go into their purview to suggest that. So as far as the voting on this, I think the other thing you have to remember is once you send it back, they do their thing according to what state regs are, and then it comes back to the council. So if you're thinking about not having councilors participate in this, you're going to have a problem there, because they automatically do per the legislative body is the final say. I think that's all, especially when you go back for conflict of interest. It's still, as Bob said, relates to monetary interest, and the discussion that a counselor could not speak on something that's coming before the planning board if it's not a direct abutter. I think that would be very restrictive to a counselor. I'll give you an example. I mean, if a counselor that lived on one side of town wanted to speak on a project on the other side of town, whether they knew the person or not, mostly, and spoke basically to the regs or to what was being built, I don't think that option should be taken away. You're kind of intruding on a resident's rights when you go that far. Just my comments, and this is a very hard discussion to have, and a lot of our regs overlap, so just some input for your consideration. Thank you.
Thank you. Anyone else? Is there, oh, good.
Sue Polidura, Middle Street, and just listening back and forth on the old 40-year-old rules. You know, the world has changed, especially Portsmouth. We used to be more smaller town families that, you know, they knew each other. They were related to me in many areas. But now we have a different type of population that just come in the last 20 years, and they may not have their grandparents that have been involved in city government. But we still have the obligation to be able to. It's like that we need to catch up with the times and the fact that we're not a smaller working town like we used to be anymore. And I was going to say, maybe we need to look at the way that other cities of similar size have dealt with this and how they have changed their rules and ordinances in order to be able to accommodate that. Because I know that they have had the same kind of conflict of interest, maybe even at a larger scale. I worked both the corporate world and I worked for the federal government for 10 years. And there are two different rules regarding what is considered conflict of interest and what is considered personal conflict of interest. In corporate, if you were someone that was directly related to the CEO, that was seen more of an, they can tell you, hey, that's who the CEO would like to have, and so you made adjustments. In the government, on the government side, everything is very regulated to separate that, which is if you're working for the government, you cannot be on the board of a corporation that is even related at having any kind of business with the government. And you cannot even run for office if you're paid for, if it's a paid for office, or even if it is an unpaid for office. But you can run for like city council and other kinds of nonpartisan entities and groups. So it's a very distinct differences between one group and the other. The city kind of government is probably more closely related to how the federal government does their business, in which if you're already working as an employee or elected official for the city government, then you should not be part-timing your skills or working with someone that does business or have any kind of relation to the city. If you are, let's say you're an accountant and you work for the city and you want to create a part-time job for yourself or an entity. I mean, it's okay if you do it for a nonprofit or if you do it for a totally unrelated group. But if you're working for someone that's already working or related to the city in any kind of capacity, well, that should be a no. And that should be disclosed. So this is just some of the observations I saw in today's meeting, and I am reminded about that situation that happened a few months ago when a city councilor who also sits on the planning board, they had to vote on another an appointment for her husband who wanted to sit on another land use board, and everybody approved it. And what I'm hearing today, when I hear this conversation, that was clearly a conflict of interest. Both of them have a business that has to do with land. So, and you got voted in anyways. So if the goal is to totally avoid anything that it would even be perceived as a conflict, that should have been addressed in a totally different way. But anyways, just giving you some thoughts after today's meeting, and I thank you very much.
Thank you. Is there anyone else? Is there anyone on Zoom that wants to speak?
Yes, I raised my hand, so I hope you saw it. This is Esther Kennedy, 41 Pickering Ave. And I just have a couple comments. First of all, I'd like to thank the opportunity of speaking with the public and seeing so many nice public members there. But I really feel that no one has reflected on the state laws. When I was last on council, I brought forward, I sit on 2 state committees. There's quite a criteria that we have to fill out for disclosing. I tried to bring it in, not the last council I sat on, but the previous one. And I think that there's a lot of information there that our state follows that I truly believe our city should be following. I also know that I and another counselor 8 years ago went to the, and I'm sure that City Attorney Sullivan remembers this and has documents of this. If not, I can present them. But we went to the local government center to have them give us information on what city officials should have under their names and part of their job description on this topic. And the local government center and their attorneys presented a very nice document that came forward to the city council and probably should be looked at again. The information has not changed. You know, I reflect back on when I was on city council, and whenever there was a conflict that might even been close. For example, when we voted on the marina and the rates for the boats down at Prescott Park, I would physically step off the council, the vestibule there, and not vote. When we voted on things with the Isles of Shoals, even though I'm a corporate member of Star Island, I'm way down one of the 400. When we voted for letting them have a space at the old library, or now called the Discovery Center, I physically stepped off the vestibule and stepped down and made a statement that that was a conflict. I guess what saddens me in watching this council currently is we have seen people vote on things that I know they're going to make money off. They voted on street. They're making money off the fact that someone can sit in front, and yet they were willing to vote. They voted on their husband being part of a planning board. That is wrong. That would never be accepted at the state level. And they got voted. I guess if you're sure that you have the votes and you're sure, it doesn't take that much to step down, but it does definitely set things right. So I would encourage, as listening to you today, I would encourage you to look at the state and federal now. The federal government has come out with some nice stuff, like you can't do business if you have certain things at the federal, given the regulations. And they're pretty clear, given some of the new information I've had in trying to write grants for my school district. So I guess I would encourage you not to reinvent the wheel, but look at what other entities that you have to associate with are doing, and take that information and build it into your plan. You know, but I do believe there have been times in the last year and a half where there's some counselors that should have stepped off, made a statement, and stepped down, and they might have been much more appreciated. And I'm sure the vote would have gone the way they wanted anyway, knowing who was still left. But just the fact that we're arguing over this is sad. Because I remember Attorney Sullivan would always say, it really is kind of up to you to do what's right. And when you asked, should I step down, he would say, if you are in doubt, then you should probably step down. And if I'm wrong, Attorney Sullivan, please speak up. But that was what you would say to me and others. And I'm sad that we've gotten to this point that we're having this discussion. So thank you for the time. Thank you for letting us speak. I'm glad to see the public there. And I appreciate that we're having a conversation at least about it.
Thank you. Is there anyone else that wants to speak? With that, I'm going to go ahead and close public comment. All we have now are announcements. The current committee schedules will continue to discuss conflict of interest. We'll come back to administrative ordinance because we weren't able to cover it today, so expect to see that on the next agenda. And I'll give updates on Blue Ribbon Committee conversions if we've heard any in parks at our next meeting. So that's likely to be a long one on May 22nd. And then June 12th, conflict of interest. I would assume we're going to keep talking about that and any additional Blue Ribbon Committee conversions. If I could get a motion to adjourn, I'll entertain that.
So moved.
I guess I'll second. All in favor?
Aye.
Aye. We are.